I have undertaken an analysis of the evidence that was tendered by the prosecution, and clearly from the judgment of the learned honorable magistrate, the learned honorable magistrate heavily relied on the evidence of PW1, who was the victim in this matter, and on the basis of that evidence proceeded to find that all the three ingredients of the offense of defilement were established and proceeded to convict the appellant. Notably, two of the elements of the offense of defilement, that is the element of age and identity of the appellant, were not in issue, since these parties were known to each other on the issue of identification, and number two, that a birth certificate was produced in respect of the age of the witness PW1. However, on penetration, there are issues. Issue number one that I picked out was the fact that on the night in question, PW1 was taken to hospital, but when PW3 gave evidence in court, that was the medical doctor, no records from the hospital were produced to show that indeed he was attended, but PW3 said when the victim went to hospital, he was attended by a medical intern. Issue number two is that the medical intern was not called to give evidence, that he was a crucial witness, and in failure to call him dealt a fact of law to the prosecution's case. He was the first person to come in contact with the victim, and therefore his evidence would have shed light as to whether or not there was defilement that was committed. The third issue that I picked was that PW1 said when he was defiled, the appellant deposited semen into him and he felt some liquid in his body. However, when PW3 testified, he said that he took a swab and there was no presence of sperm, so therefore raising doubt as to whether indeed there was such act of defilement. The other aspect that I picked out in this matter was that the learned honorable magistrate did not consider the defense tendered by the appellant exhaustively, whereas the learned honorable magistrate stated that she did not find evidence of any problem between the appellant and the family. Apparently, the court did not look at the evidence of there being a problem between the appellant and PW1. PW1 had cases of indiscipline, one being that he was caught with a mobile phone in school, which was not allowed, and that mobile phone was said to have contained pornographic material, therefore providing a basis for motive for this victim to frame up the appellant. There was also the question of the conduct of the PW1. The PW1 testified that after the incident, the appellant went to open the gate, leaving him standing there, and then thereafter he boarded the motor vehicle when the appellant is said to have been driving towards their home. That conduct in itself raises many questions. Is it true? Is it possible that one would defile and carry his victim to their home? That defeats common logic and the ordinary course of things. Now, the evidence of alibi that was given by the appellant and his witnesses was not considered at all. The failure to consider that evidence again rendered the conviction unsafe, in that the appellant has no duty in law to prove his alibi, and all that the prosecution is required to do is that once an alibi is tendered, the duty is on them to discount it or displace it. There was absolutely no evidence to lodge that alibi, and even in their submissions, the prosecution never commented on that defense of alibi, as well as the magistrate in our own judgment. After a careful analysis of the entire evidence, The view of this court is that this conviction was unsafe. The same is set aside together with the sentence imposed against the appellant. Going to be uploaded shortly.
Much obliged, my lord.
For your reading.
Much obliged, my lord, and we thank the court for that reasoned judgment. Thank you very much.